As everyone is aware, the TRC in its sixth call to action recommended repeal of Section 43, and it did so to break with the legal and state systems that facilitated genocidal abuse against Indigenous children in residential schools. In weighing repeal today, it's important to recall that Section 43 is far narrower than it was historically. As you're aware, the Supreme Court of Canada read in significant limitations in 2004. One of the potential impacts of repeal today is that it will contribute to a harsh culture of state intervention, including child removal, to which Indigenous families and children are disproportionately subject. In fact, I would argue that expanding criminal liability for parents may undercut recent initiatives to promote Indigenous sovereignty over child protection, including the 2019 Act respecting First Nations, Inuit, Métis children, youth, and families. And this brings me to my second point, the potential legal effects of repeal. Canada defines assault in Section 265 of the Code very broadly to include any non-consensual physical contact beyond a de minimis level. So how will the situation of repeal change this legal baseline? Let me give you a brief example. Let's suppose a mother is placing a 5-year-old in a car seat and the child keeps kicking at the parent and insisting they want to ride without a car seat. After struggling with the child and receiving several kicks to the chest and the chin, the mother strikes the child twice across the shins and instructs the child not to resist being placed in a car seat now or in the future. What are the potential consequences for the parent and the child if this incident comes to the attention of police, and how might that attention even happen? Well, the parent could be in a high conflict divorce or acrimonious family situation where the other parent will be interested in pursuing this as a criminal matter. Or let's imagine this is a racialized family, a family recently arrived in Canada, or a First Nations family who, for unrelated reasons, is subject to monitoring by child welfare. In a visit from a child welfare worker, the child will be interviewed separately from the mother, this is standard practice, and asked if the parent ever hits the child. The child might then explain that the mother hit their legs a few days ago getting into the car. It's very possible with repeal that at such a point, there would be some involvement by police if child welfare workers and others in authority are aware that Parliament has repealed Section 43 and such an incident constitutes a criminal assault. This brings me to my third and final point. Who is most likely to be subject to punitive intervention? This intervention may take a range of forms. It may mean at least some contact with police, perhaps a warning, but perhaps a charge, perhaps a diversion by the Crown, but perhaps also an assault charge that proceeds and to which the parent may ultimately plead guilty. That's statistically by far the most likely outcome where a charge does proceed. And the parent may ultimately be given a conditional discharge that allows them to avoid a criminal record if they abide by certain conditions, but they may also be given a conditional sentence to be served in the community, but for which they will have a criminal record. I will wrap up now.
Thank you. And you'll have a chance to respond. I think you're probably going to get a lot of questions. So thank you very much.
Thank you.
Monsieur Levasseur, pour 5 minutes, s'il vous plaît.
Merci. Mr. Levasseur, you have 5 minutes. Thank you very much. My name is Marc Levasseur. I'm a Canadian by birth, descended from Western and Indigenous ancestors from the Algonquin and Mi'kmaq nations. As an adult, I was traditionally adopted by an elder of the Atimakek Nation, and I've been living in relation to the Wemutachi community since then. Among my accomplishments, I hold a master's degree in theological studies with a concentration in Indigenous studies, and I'm in the process of completing a bachelor's degree in social work. I have also worked as a correctional officer with the Correctional Service of Canada, as well as spiritual and social worker within Indigenous communities. Since 2017, I have been on disability due to the trauma I experienced during my childhood. Section 43 has existed for 132 years in the Criminal Code, with the purpose of protecting Western Christian ideological excesses that have for centuries asserted that a child is born tainted by sin and must undergo punishment to atone for their faults. While Western Christianity considers it morally justified to strike children, such a conception did not exist among First Nations. In Atikamekw, a young child is referred to as awajish, which means the little being of light in reference to its purity. This is why the shock for Indigenous children faced with educational violence in residential schools was so brutal. From its inception to today, this section embodies the colonial legacy of educational violence in Canada. My biological parents told me about the educational violence they endured at school from teachers, and my adoptive mother was forced to attend Indigenous residential schools where she was subjected to the regime of corporal punishment that prevailed in these institutions. This section has a lot of blood on its hands and is an anachronism completely at odds with current culture and educational philosophies promoted in Canada. The legacy of this section dates back to a time when it was legal, enshrined in the Criminal Code, for men to have the right to use force to reasonably beat their wives, and when it was common to sanction adults to various forms of corporal punishment in prisons, including the use of a wooden paddle and a strap. These abuses towards adults have disappeared from practices and laws since the 1960s and 70s, but not for children. Our society has chosen not to give children the same level of protection as adults. It is time to correct this, because even today, despite the provisions of the 2004 Supreme Court ruling, thousands of children here in Canada are growing up in environments that promote educational violence with complete impunity because the content and spirit of Section 43 align with this. For my part, since birth, I have been confronted with a systemic environment of educational violence within evangelical Baptist communities. While some Christian groups have put an end to the excesses of educational violence, evangelical Baptists, like others, continue today to defend these practices and are among those advocating to maintain and strengthen Section 43. In our families and within the church, we were taught that being hit on the buttocks with a wooden paddle or a strap was normal and for our own good. For them, it is a divine mandate, and they believe that one who loves their child must punish them. As a society, we should consider that hitting a child's buttocks as an assault of a psychological, physical, and sexual nature. Yet, this act is considered educational and is still protected under Section 43. I endured these systematic abuses from my parents and church school staff. For various and trivial reasons, such as turning around in class, I received at the ages of 4, 5, and 6 paddle strikes in the church basement. There were about 90 students in this church school. Receiving violence from people from whom I should have received love, security, and kindness led to a rupture of emotional bonds, attachment difficulties, a toxic view of myself, anger, and violence that I had to fight and still fight today. As a young adult, I struggled with substance abuse and homicidal ideations. I have lived with symptoms of complex post-traumatic stress so intense that I have required psychiatric care. I've been in therapy for 10 years now, and I take medication daily. I often wonder what my life could have been without these educational violences and how I could have contributed to our society instead of being a burden on it through the treatments my conditions requires. Mr. Levasseur, I have to interrupt now, but you will have the opportunity to answer all the questions. Thank you very much.
Mr. Lutz, President Lutz, 5 minutes, please.
Thank you, Chair, and thank you for the opportunity to speak today. My name is Ryan Lutz. I'm the president of the Nova Scotia Teachers Union, and we represent approximately 10,000 teachers and educational specialists in Nova Scotia's public school system. And I'd like to acknowledge that I live and work on the unceded territory of the Mi'kmaq people. Teachers are absolutely committed to reconciliation, and we support 100% the Government of Canada's commitment to enact all TRC Commission calls to action. The NSTU is committed to this support while also being committed to keeping our schools and classrooms safe places. As such, the NSTU opposes Bill C-273 if it is passed without other amendments to the Criminal Code. And this is simply because a repeal without amendment will lead to more unsafe classrooms. Student violence against other students, themselves, and educators is on the rise. Now more than ever, we need laws in place to help teachers ensure schools are safe for everyone. It is important that the views of teachers are reflected in your deliberations and decisions. Repealing Section 43 is extremely important, but we have to get it right. Teachers on the ground in the classrooms of our schools, of our country, have not been afforded meaningful consultation, and teachers do not support the bill passing unamended. As the NSTU president, I'm first and foremost a teacher. I'm a high school math teacher, and I can tell you that no teacher wants to physically intervene. No one, like I think Mr. Caputo said, no one gets up in the morning wanting to break students apart. But unfortunately, that need is increasing. I personally have been in situations where I've had to physically intervene to restrain students. And without me being able to do that, there may have been a violent assault in the halls of my school. And again, unfortunately, this is not a unique situation. Numerous situations arise in the school context that require a teacher to respond. These responses might include a teacher placing their hands on a student's shoulder to guide them away from an altercation, or restraining or redirecting a student to protect student safety. Under Section 265 of the Criminal Code, these everyday actions could be subject to prosecution. The repeal of Section 43 would put a chill on teachers trying to do their jobs. It may cause them to stop from ever intervening in difficult situations. And this would compromise the safety of our schools. The unfortunate reality is that 92% of Nova Scotia's teachers have witnessed violence in their schools and classrooms, and 55% have either been the victim of violence or been threatened with violence. A school safety amendment would ensure the specific protection of teachers and educational staff within the criminal code in situations where reasonable physical intervention is necessary to protect the safety and well-being of our students, teachers, and education workers across our country. The Canadian Teachers Federation draft language, which the NSTU supports, seeks to amend Section 265 of the Criminal Code. The amendments would honor the Truth and Reconciliation Commission call to action while also ensuring that teachers can promote safety in our classrooms and schools and protect the safety of a student, which I would remind the committee is the scope of this. The scope of this bill is about protecting students, and that's what teachers seek to have amendment through this. It's near and dear to our heart to protect students. That's what we all want. It's important to recognize that pursuant to Nova Scotia's Education Act and likely other acts around the province, teachers have the legal duty to protect students, to maintain safe classrooms. And in order to do that, we must have protections in the criminal code that allow us to use reasonable force only when necessary to ensure that our classrooms are safe. Without a school safety amendment, the NSTU anticipates there would be an increase in the number of assault charges filed and prosecuted. The NSTU would have to advise Nova Scotia's teachers, as a precaution, to not physically intervene in situations noted above. This would result in more injuries and more severe injuries to students, and it would result in schools being less safe. And thank you. One of the things that I think has come out here is there's teachers need to be able to act reasonably without doing a risk-reward analysis of section. We're not lawyers. I need, as a teacher, to be able to grab a student who's running out into the street. I need to be able to pull on someone's hand if they're running towards an altercation. And I need to be doing that without weighing the risk of common law defenses or doing some legal analysis in my head. I need to be able to act reasonably in situations just as a reasonable, loving parent or teacher would. And that's what we're really asking for today. So thank you for having me here, and I look forward to responding to your questions.
Thank you very much. We will now move to our first round of questioning. We will start with 6 minutes each and begin with Mr. Taco Van Popta.
Thank you, Madam Chair, and thank you to all our witnesses, Mr. Lutz, Mr. Levasseur, and Dr. Kelly, for being with us here today and helping us through this very important draft legislation. So, Dr. Kelly, I'll start with you. We're talking about possibly repealing Section 43 of the Criminal Code, which is a codification of the common law defense available for teachers and parents to charges of assault against children. And the Supreme Court of Canada weighed in on this issue 20 years ago, and the Chief Justice at that time said this about Section 43, which they defended as being constitutional. She said, "The reality is that without Section 43, Canada's broad assault law would criminalize force falling far short of what we think of as corporal punishment, like placing an unwilling child in a chair for a 5-minute timeout." So, Dr. Kelly, we heard from earlier witnesses, including the sponsor of this bill, about horrific stories about children being hit in the face, being hit with sticks, physical abuse. So I would like your comment. Does Section 43 protect that kind of behavior?
Thanks for this question. No, it does not. So as you've alluded to, in 2004, the Supreme Court of Canada read in a series of limitations as to what would constitute reasonable correction when it upheld Section 43. It made clear in that decision that in the case of teachers, corporal punishment of any kind is not included in Section 43, only forms of restraint in cases, for instance, for protecting themselves or other students. And in the case of parents, use of instruments, blows or strikes to the head, contact, physical discipline of children under 2 or teenagers were all read out of the ambit of Section 43. So the only maybe slight caveat I would have to the question is that with respect to, for instance, grabbing a child if they were about to run out onto the street, it's not my view that that would be criminalized if Section 43 were repealed. There would still be necessity defenses in the case of an immediate action to protect a child. But the example that I gave of a strike, for instance, to the leg of a child resisting in a car seat would be within the ambit of 265 and would not be captured. But the more horrendous examples that you gave have indeed been read out. And I have reviewed the case law since Canadian Foundation was decided, and we simply do not see courts today upholding the kinds of egregious abuse that they did prior to 2004.
Thank you for that. If Section 43 were to be repealed, in other words, if this private member's bill does pass through Parliament, in your opinion, would the common law defense kick in again? And what would be the message to the public of repealing Section 43?
So the defenses that would continue to exist and that continue to exist right now alongside Section 43 are those that exist generally for any types of physical contact with anyone, not specific to children. That would include self-defense, force that's used in defense of oneself or a third party in a case of imminent danger. The defense of necessity I referred to, when you take an action in an urgent moment, for instance, to prevent someone from running onto a street, those would remain. But outside of that, non-consensual touching beyond a de minimis level, beyond a minimal threshold, would be considered assault. And the message that would be sent, I think proponents of repeal hope that the message will be that all forms of physical discipline are wrong and unlawful. But I think we also have to be attuned to the message that will be sent to police, child welfare workers, and prosecutors, which will be that those forms of my example of striking the child's leg in the car seat, for instance, that all those forms of contact will be assault, and that for particular families, especially those most marginalized, we may indeed see, I would expect to see further cases of that kind that actually go through the system.
Sorry, one quick question. We had witnesses here at our last meeting pointing out that that Parliament never responded to the 2004 decision from the Supreme Court of Canada, that perhaps it is time to expand or to further define this Section 43 defense by basically codifying what the Supreme Court of Canada said. For example, clarifying that force must be sober and reasoned. Force cannot be applied to a child under 2 or over 13, et cetera, right? The items that were listed in the Supreme Court of Canada. What do you say about that? Would that be a good idea to have for example, a Section 43.1 that explains that?
We're going to have to wait for the response to another question, just simply to let other members have their turn. Sorry about that. So, Madame Brière.
Thank
for
you,
6 minutes.
Yes.
Ms. Brière, you have 6 minutes.
Levasseur, est-ce que vous aimeriez?
Mr. Levasseur, would you like to have an opportunity to finish your opening remarks? Why is it so important for you to be speaking today? Well, I would give you 3 reasons. First, I myself have lived experience. And despite all the efforts I have made to rebuild myself, I have this inside me now. I have this legacy with profound consequences. I've had mental health diagnoses. I take medication on a daily basis just to control the levels of adrenaline and cortisone in my body, because it disables me in my daily life. And I'm perfectly intelligent. I'm perfectly capable of making contributions, but I have been disabled. And I don't know how much I'll be able to recover my capacity, my abilities from this. Now, I brought a wooden paddle with me. This is what we were corrected with at the church school. It was shown in court. It is an exact replica. And this is a symbol of what Section 43 was from 1892 up to 2004. Now, I do understand that there was clarification on the part of the Supreme Court in 2004. However, Section 43 was designed for the use of things like this paddle. And this paddle is a symbol that represents that section. Now, since 2004, I do know that limits have been set out by the Supreme Court, but that doesn't change the fact that groups of Christians, for example, evangelical Baptists, who were using paddles like this up until 2004, are now saying, well, you can use your hand. And they actually encourage parents, based on religious grounds, to strike their children if they love them. Now, I think this is an aberration. Whichever good man or woman would have the right to reasonably strike the buttocks of their young 3-year-old girl, for example, 5 or 6 years old. Would an adult do this to someone else without their consent, to another adult? It would be called sexual assault. But a father can strike the bottom of their child, of their girl, with no consequences. And as long as Section 43 is in effect, then these religious groups can continue to promote this kind of punishment based on religious grounds. They can still tell parents in their churches that their parents can slap their children, strike their children. This is a legacy that has had an impact on First Nations as well. It's not part of First Nations culture. Do you know, children are called a symbol of light. And that is completely at odds with Western Christianity that pointed out that children were born stained by sin. And so adults could strike them. But within Indigenous communities, that didn't exist. That concept didn't exist. Now, I've heard questions asked about the effect that the repeal could have on parents. I just would like to say this. At some point in time, one has to break with cycles, and there has been a cycle of educational violence in Canada. It's been enshrined in our law. At some point in time, that cycle has to stop. We're at a point in our society where less and less parents practice these kinds of things. They're less and less part of our culture. It's less and less accepted. But there's a legacy that goes along with these laws. It's a colonial legacy, and it has to disappear.
Justement, vous entendez les différents
Thank you. So yes, in fact, you did hear comments on the part of others and part of other witnesses, and I'm wondering if you've heard the previous testimony as well. And now, Dr. Kelly pointed out that there could be undesirable potential effects of repealing Section 43. For example, let's say a couple that is currently divorcing, and they could use, for example, they could lay criminal charges against the other parent, for example. Well, I would say this. So, if corporal punishment were to be stopped, were to be forbidden, then children would become less and less raised in these violent contexts. So there would be less and less punishment perpetuated, corporal punishment. I also think one has to think about child protection services, for example. I've been working in the social work area, and I had a discussion with a professor recently. So he was responsible for assessment within child welfare services, and what he was saying that 80% of children from whom their children were removed didn't necessarily lead to these people have criminal charges being brought against them. However, these children are going to be living with the after effects of the punishment they received, and no action was taken against these parents. Thank you. Thank you, Mr. Levasseur. We'll now move on for 6 minutes to Mr. Fortin. Thank you very much, Madam Chair, and thank you to all our witnesses today. Mr. Levasseur, I was very moved by your testimony, and please rest assured that for my part, and I think I can speak for everyone, that we completely sympathize with everything that you have experienced in the past. Now, please correct me if I'm wrong. What I understand from your testimony, Mr. Levasseur, is that you are against the use of corporal punishment, and I absolutely agree. You've probably heard other witnesses before yourself who have spoken about teachers or parents who have had to use reasonable force. And they've had to do this, for example, to control a children or two children who are fighting, and they have to separate them. Now, it appears to me that one has to be able to make a distinction between corporal punishment and the use of force that may be necessary at times within these educational contexts by whomever has that authority, whether it be the teacher or parent. So I'd like to hear you on this. Do you think we need to be cautious and be able to separate out these two things, corporal punishment and the use of reasonable force to ensure the safety of children? Well, first, I think that Section 43 has to be repealed because of its legacy, because it represents a correctional force. Now, that's the first point. Second, I'm a parent myself, and I'm also a former correctional officer. My companion is a special ed teacher, so I'm very aware of what can happen, and I'm very aware that one has to sometimes be able to use force, and I'm also aware of what it means to have children. I have discussions with my own companion who at times, yes, has to use a physical force. Now, if there's a need for these things, and personally, I have reservations. However, if there is a need for this, then there has to be a separate section, a separate part of the law. Within the criminal code, there are already provisions for the use of force. For example, when there is imminent danger for oneself or for another, when there's public or disturbing the peace, for example. I've had to use force as a correctional officer. I had to do that when I was working in a hospital context. We had to use physical force to be able to restrain people. No one was ever charged for having to use force. I've had to use it in correctional contexts as well. I had to use it several times. I've had to use it in my personal life. I've had to use it in my civilian life as well. When you see a fight, for example, when someone is assaulting someone, well, I've seen cases like that, and I've had to be able to restrain someone in order to prevent that. I was never charged, and that's because there is legislation that guards against this. Now, in terms of children, let's say that there is a child who understands reality differently from the rest of us. For example, a child who is autistic. And let's say they go into the street, for example. They're posing a danger to themselves. But in that case, someone has the right to use force to protect them. Now, if this child were to take off into a field where they don't represent a danger to anyone else except to themselves, now if someone were to jump on them and use force, well, okay, it may be subject to debate then. Thank you, Mr. Levasseur. I'd like to raise another issue that is a rather delicate one. I appreciate listening to your explanations. You've spoken to how children are perceived within Indigenous communities and that they represent light. Now, we've looked at various pieces of legislation, and what we know is that there is an overrepresentation of various groups in our legal system, in the correctional system as well. And I'm wondering if repealing Section 43 wouldn't have an impact on these overrepresented groups. And what would the impact, do you think, be within Indigenous communities? I have a good idea of what you're going to tell me, but I would like to hear you on this, Mr. Levasseur. Thank you. Well, I don't necessarily agree. Is there going to be overrepresentation because of repealing Section 43? Will there be more prevention? Will the line be moved? Will the line be moved between violent use of force or a necessary use of force? I think the line will be much clearer. Thank you very much. I only have about 40 seconds left, so I'm just going to move on to something else. How would repealing Section 43 then lead to any kind of improvement within Indigenous communities? I understand the moral implications of Section 43. I know there's a past attached to that. We don't need necessarily to go back to that. But how would repealing Section 43 actually help Indigenous communities? Well, beyond the legacy, it would help just draw that line. It would break with these cycles of violence that have been perpetuated through education in Canada and that can still be perpetuated because it's still allowed. There's a very large gray zone. Thank you. Thank you very much.
Mr. Garrison, please.
Thank you very much, Madam Chair. I want to start by thanking Mr. Levasseur for bringing his very powerful personal testimony. And I think as parliamentarians, we don't often credit the bravery and the difficulty for people to do that. So I thank you very personally. But I think you've done something else very important in addition to that, and that is you've taken us back to the kind of first causes. So why did we ever decide that violence against children was acceptable as non-Indigenous Canadians? And I'd like you to say a bit more about that difference that you talked about in your opening statement that causes us to say, even today, you can't use force against adults, but with children, it's somehow okay.
You mean specifically in Indigenous context?
Well, the contrast between non-Indigenous and
okay.
Indigenous approaches to that question.
OK. Ben, c'est le contraste en réalité.
Well, if you go back through colonial history, Christianity, those who are familiar with Augustinian principles, children are born tainted by sin. So they're already seen as bad within that approach, that perspective. I've looked at the various scriptures, and so there's this belief, and it's actually spelled out, that a rod will spare them from this. Well, we'll correct that tainting. And that view dates right back to the Middle Ages. And through the church, it has been perpetuated through colonialism. Indigenous communities and groups did not have that same vision of education. They did not have that same view of children. The Western view has a very hierarchical approach. There's the father, the woman was below the man, and then there were the children. And they were actually seen as belonging or the possessions of the parents. But within Indigenous communities, you have a circle, not a triangle. And the child is seen as awashish, and they are a symbol of light. And that represents also the energy of the Creator. So they were not only the symbol of purity, but at birth they were actually a miracle of life. They were literally a reflection of the Creator coming into this world without necessarily being the Creator. Let's be clear. I don't necessarily want to sound like what the Christians used to sound like, but they were seen as being pure. They weren't seen as property. And what did residential schools do? Well, they took these children, and their perspective of the world was very, very different. There was good and bad, and these children were told that their parents were heathens, that they were heathens. Corporal punishment was used to rid them of evil. And that was a huge shock. It was a shock that they felt that became part of them. And so this vision was imposed on them. And these children really were subject to this vision of the world, and then they returned to their communities with that violence in them.
With the little time I have left, to Ms. Kelly and her third concern she raised about the impacts on marginalized people of repealing this section. I'm not quite sure that I understood your concern there. So, Dr. Kelly, can you maybe go through that again with me?
Sure, absolutely. So we know that in both the child welfare and the criminal legal system in Canada, that Indigenous peoples, racialized people, especially Black people, and poorer and working class people are overrepresented, and they're over-surveilled as compared to their more affluent, whiter counterparts. A concern is that not that if Section 43 is repealed, that in the morning we will see swaths of parents being arrested across the country, but that those who are already within and more heavily surveilled systems will have these types of incidents come to the attention of state authorities and worked through at some level the criminal legal system. and that there will be gendered and racial and class elements. For instance, we know that in Ontario, of cases of child maltreatment that have been found to have been verified as of 2018, that 86% of those cases involve biological mothers, 90% of them involve female carers. And we also know that uses of physical discipline or non-consensual touch are more likely to occur in homes where there is greater economic stress, in single-parented households, et cetera. And so I believe that what we will likely see is a continuation of these forms of inequality. I think it's important to note, yes, this defense is a colonial one, but the entire criminal code is a colonial construct that was imposed in the late 19th century, and it's that part of the system that will be aimed at this kind of contact.
Thank you, Dr. Kelly. We will now move to our second round with Mr. Moore for 5 minutes, please.
Thank you, Madam Chair, and Mr. Levasseur and Mr. Lutz and Dr. Kelly. You've all had fantastic testimony today. This is a great panel that I'm sure we could go on because you've all had so much to offer on this discussion. So we really do appreciate it. And you know, you look at Section 43, we can look at it in the historical context, but we also, as we sit here today, have to look at it in the reality of what the law does and what the law does not do here in 2024. And we are dealing at Section 43 now, not as it is written in the code, but also as it has been significantly interpreted and narrowed in a leading Supreme Court of Canada case, a case that had it not existed, Parliament itself may have taken similar action. So I know when the bill was introduced, Dr. Kelly, I'll address this to you. When the bill was introduced, the proponent mentioned in their opening remarks some actions that clearly, my view is that they fall outside of the scope of Section 43. And but I want to get your opinion on it. For example, punching or slapping a child in the face. Do you think that is that there's a defense in Section 43 for that, as interpreted by the Supreme Court?
No, I do not.
And paddling a child or striking a child with an object?
No, I do not.
Okay. And leaving a bruise, slapping someone and leaving a bruise on their cheek,
no.
Section 43, no. So, and we also know that the court narrowed the application of Section 43 for corrective to those that are 2 and over and not yet teenagers. What about teachers administering corporal punishment? Does Section 43, as interpreted by the Supreme Court in this leading decision, Section 43 then, as it appears before us in Canadian law, can teachers administer corporal punishment and be protected by Section 43?
No, they cannot.
Okay, and thank you for your quick answers, because I think that's the reality that we're dealing with here today. There was a reality before, but then there's the reality in the law, and that's what, with this private members bill, we are vested with today. And I think I've seen some of the dangers that have been highlighted with just simply abolishing Section 43. Mr. Lutz, you mentioned, and we heard previous testimony on this, the chilling effect it could have on teachers when it comes to breaking up a fight. And I, as a parent, I find that remark kind of horrifying when you think if someone is being beaten by a school classmate or by a couple classmates, and you only have to look on your social media, this is happening all over. It's being posted. I know you're from Nova Scotia. I'm from New Brunswick. We're seeing this across the country and internationally. Video of fights at school. it's not an easy environment that teachers are in. Can you speak to a bit this chilling effect that you as a leader would be the message you would be sending to your teachers if this protection is not there?
Yeah, absolutely. And thanks for the question. And first off, I want to say, the NSTU opposes violence against children. Period. Full stop. And corporal punishment as well. That is not what we're speaking to. I also agree with the Monsieur Levasseur that I think it's really important to repeal Section 43. It's just important to get it right. So I appreciate the colonial legacy that Section 43 has brought to us. We have to do away with that. Section 43 should be repealed, but it should be done so while at the same time protecting teachers in schools. And the unfortunate reality is that our schools are more violent than they were, and that's not a reality that I want. I have 2 kids. That's not the reality I want for them. I also want their teachers able to protect them and keep them safe. And I want them to be able to do that without doing a mental calculus of, do they think that the criminal law is going to protect them or not? So I think we can do both. I think we can repeal Section 43 and honor the Truth and Reconciliation Commission while also amending the criminal code to make teachers able to keep their kids safe at school. That's what we want. And at the end of the day, it's, again, parliamentary procedure is not my expertise. I'm a math teacher. That's where we look to you. But if we can't get this right, I think that's where we have to put our efforts. We have to put our efforts into doing both things at once. And I believe this committee and the esteemed folks around this table can do that, can repeal Section 43 while also ensuring that teachers and schools have the tools they need to keep our kids safe. So I would just implore that the folks around this table go back and do both of those things. But to do one of them without taking into account the other, I think, would put our teachers and our schools at risk.
Thank you, Mr. Lutz. We will now pass to Mr. Maloney, please, for 5 minutes.
Thank you, Chair. I want to agree with what Mr. Moore just said. This panel has been very informative, as all the panels have been on this issue, frankly. And I'm glad, I think Mr. Moore used the term a dose of reality or being realistic, because this is the part I'm struggling with. I mean, we can all give examples around this table of extreme cases where a change would not work or would work, or if the status quo doesn't work. So we need to sort of parse that out and get to the core of the issue. So, Mr. Lutz, for you, sir, to start with, the Nova Scotia Teachers falls under the jurisdiction of the Canadian Teachers Federation, I'm assuming?
We are a member of the Canadian Teachers Federation.
Okay, because Ms. Yetman said in her testimony earlier today, and I think you were here, that if Section 43 is repealed, that it would be their advice to teachers not to touch or lay a hand on any students. Do you agree with that approach if that's what happens?
So that is what our legal experts are saying, is that would have to be, that's not a world I want to live in, but that would have to be our advice for teachers moving forward.
Okay, so I want to pick up on something Moore just said. Let's assume this is a grade 7 class. You're the teacher, and Mr. Caputo and Mr. Moore start to beat me up. If Section 43 is repealed, are you going to tell your teachers that they have to stand by and watch that happen and not inject themselves and to try to break up the fight?
I mean, again, I certainly hope not. What are legal?
Well, no, it's not hope. This is a very realistic question.
Yeah,
because the evidence is that they will tell their teachers not to touch their students. I'm giving you a real scenario. It happens in classrooms all the time.
Absolutely.
So what would you do as a math teacher in a grade 7 class if those two guys start beating me up?
So let's just be clear. What our legal experts are saying is that our advice would have to be not to lay your hands on kids, period. What I would do as a math, if I can finish my question, do you mind if I finish the question? Because I think it's really important. What I would do as a teacher in that class is I would intervene. I would find someone to intervene. But I don't want our teachers to have to go through some nuanced legal analysis. I want them to be able to take really reasonable reactions in the moment to keep kids safe. And that's where our legal experts have said, without Section 43, we would be putting teachers at risk. And I don't want to live in that world. I want to live in the world where the teachers can intervene reasonably to keep kids safe and know they're protected. And that's what I really want to be clear, because our position is very nuanced. It is Section 43 should be repealed. while at the exact same time additional protection should be given so that teachers and schools have the tools in their toolbox to keep kids safe. We shouldn't be doing one without the other. Section 43 should be repealed, and at the same time, and it's really important that it happens at the same time, we must include the school safety amendment to ensure that teachers are not prosecuted for, again, very reasonable interventions to keep kids safe.
I don't disagree with you, Mr. Lutz. Unfortunately, I think perhaps the position might be over-nuanced and over-legally analyzed, to be honest, because I don't think there's a scenario where the example I just gave, where a court's going to hold you responsible for breaking up a fight and protecting one student from two other students or one other student. And I don't think the repeal of Section 43 would create that exposure. I think you would still be allowed to do your job in the same way we are now. Section 43, as we've heard time and time again, was introduced at a time and place that is entirely different now. And it's entirely different than it was prior to the Supreme Court of Canada decision as well. So I want to move over to you, Dr. Kelly. Let's assume that Section 43 is repealed, and let's assume that a student or a teacher rather is charged with an offense, as they could be now, because I don't think students or teachers or parents know that Section 43 exists until they hire a lawyer in a particular situation. Do you not think that the Supreme Court of Canada, as they've laid out in their decision, that would still provide guidance to courts in analyzing a particular set of facts when a teacher's put in a position where he has to defend himself against an assault charge?
Yes, absolutely. If a teacher, if anyone is charged with an assault and there is a need to apply or to interpret Section 43, a court does so in accordance with
I'm saying in the absence of Section 43, that would still provide guidelines to judges who are reviewing the facts of a case against a teacher.
Well, in the absence of Section 43, then you would be interpreting the contact as you would under general Section 265 assault jurisprudence.
Are you saying that Supreme Court case would have no bearing whatsoever? Is that your position?
That's correct.
We will now move to our last two questions at 2.5 minutes, please, to Monsieur Fortin.
Merci, Madame la Présidente.
Thank you, Madam Chair. Ms. Kelly, I'd like to continue with you for these next couple of minutes. From what I've understood from the various testimonies is that corporal punishment must be forbidden and must not be allowed under Section 43, even though with the interpretation of the Supreme Court it's already forbidden. But there's an amendment, there could be an amendment that would forbid this type of corporal punishment. So one could forbid corporal punishment, but at the same time, there could be allowance for the use of reasonable force for the safety of children. Would that not work?
Would be for an amended Section 43 or a new provision, if 43 were repealed, as one of the earlier members questioned, to actually codify the limits and the narrowing that the Supreme Court undertook in 2004 as a rewritten provision, such that anyone who picked up the code would be aware of the limits as they exist right now. Is that the question? So that could absolutely be done as an amendment to Section 43, or perhaps as a new defense.
Merci. Oui, il me reste que...
Thank you very much. And I only have a few seconds left. So, Ms. Kelly, yes, you understood the question. Thank you. But beyond the whole legal aspect, that is to say whether it should be codified or not, I'd like you also to speak to the substance of this. Do you think, in the light of your expertise, that it would be a good idea to allow the use of reasonable force for the safety of children in these educational contexts, avoiding corporal punishment?
Yes, I think that in some of the situations that have been raised in an educational setting or otherwise, there may need to be instances where, for the protection of students, a teacher will want to intervene. And it may be an intervention that wouldn't be fully captured by or excused by the current law of self-defense. I think there are some unique considerations with respect to young people that don't always apply, for instance, to adult-adult relationships.
Merci beaucoup.
Merci beaucoup. And for
Thank you very much.
minutes to Mr. Garrison, please.
Thank you very much, Madam Chair. And this is the only advantage of being the fourth party is quite often I get the last question. I just want to say thank you to the Teachers Federations for assigning us homework as members of parliaments to go along with this private members bill, because I do think they raised important points and concerns. But I want to end with a question to Mr. Levasseur, who was very eloquent on both the historic harms and the current harms of the existence of this. And Mr. Levasseur, I wonder if you could talk a bit about what you think the impacts of repealing this section would have in terms of reconciliation and breaking the cycle of violence in families.
Premièrement,
Sorry, I'm just sorting my thoughts out in French. First of all, repealing this section sends a message that this was wrong. For years, even myself in my personal life have known Section 43, have been aware of it. And most of the people don't know about this provision. Even within the social work setting, people are surprised that Section 43 still exists. But I myself, since I've been very young, have been familiar with Section 43. Why? Well, because that's what gave the right to my parents and to the educators to use corporal punishment on me. We've heard that since 2004, corporal punishment has been forbidden. Well, that's not exactly true. It's restricted, but it hasn't been forbidden. So the Canadian legislation still has not said that corporal punishment is absolutely forbidden. Under Canadian legislation, physical punishment is allowed in a narrower context. But a father can still reasonably strike the bottom of their little girl. It's still allowed under Section 43.